lesson. Learn the rule. I know, unimaginable, right? So tricky, so difficult. Who needs that? Look to the case of Dunac v. Dunac, a 2026 case published in March in most law research databases. Reading to you from the case. The narrow issue, in other words, one part of one issue, very minute and yet of ultimate consequence, is whether the husband complied with Florida Family Law Rule of Procedure 1, 2, or 12.490E as in every, and the number 5, which provides that a party seeking review of a motion to vacate an order, in other words, get rid of the order, I don't like the result, the order was decided by incorrect law or through the wrong information or there was some procedural defect, must seek to schedule a hearing date at the same time that the motion to vacate is filed with the court. The rules are a little different for lawyers who generally have to do a meet and confer. Nevertheless, the court concluded that the rule requires some action directed at securing a hearing date beyond language requesting a hearing date in the motion itself. A motion is not enough. Anybody can file a motion, but if nothing ever happens and nobody ever seeks to have a hearing, the motion may as well have never been filed at all. Eventually, it will be stale, a case will be dismissed, or the motion will be forgotten. Courts and judges have too many cases and too many things to do to go chasing every motion filed by every party in every family law case just because. And sometimes people file a motion as a threat, as a warning shot across the bow. Sometimes people file a motion in order to trigger a joint stipulation or some other settlement. In other words, hey, buddy on the other side, I have you dead to rights. I filed a motion. You had best comply and do the right thing in good faith, or else I'm going to have the judge sanction you in some way, shape, or form. The case in the DCA, the Fourth District Court of Appeal, went so far as to use Merriam-Webster's dictionary to define the verb seek, which includes to ask for or request, and to try to acquire or to gain. Legal practitioners love definitions. Here, the husband did ask for or request a hearing in his motion to vacate, but he did not do anything other than that. He didn't contact the court, didn't contact opposing counsel, and therefore he did not try to acquire or schedule a hearing date within the meaning of the rule. He only requested one. He didn't take any forward steps, any quote-unquote affirmative action. Therefore, we agree with the former wife that if a party could satisfy Rule 112.490E5's procedural obligation to seek to schedule a hearing date by a sentence asking for a hearing and a motion, then the seeking to schedule requirement would be reduced to a hollow formality. Affirmed. How about that? New lawyers are sometimes a little bit too arrogant to look to the rules, and older practitioners generally know the rules and can run circles around younger practitioners who do not know the rules or who do not follow the rules. And this is a lesson, ladies and gentlemen, that when you go to work, it is not law school anymore if you are a new lawyer. When you go to work, and you have your first job or open up your own law practice and you do not know everything and nobody knows everything, FYI, here's a lesson to you. Look at the rules. Read the rules. Follow the rules. That is why they are called rules, established by the legislature, established by the district courts of appeal, established by the Florida Supreme Court. These rules are there for a reason, so that we are not the Wild West where anybody can do anything at any time with impunity. These rules are there as safeguards and guardrails to ensure that at least most practitioners will follow the rules and play within a certain structure for purposes of equity and fairness so that nobody can run roughshod over somebody else by being duplicitous, sloppy, or willfully ignorant of the law. Thank you very much.